We don't talk much about juries in this class because our focus is more on what's called motion practice, so all the stuff that happens around the trial. But it is important to know about the role of the jury and some basics about how juries and jury members are chosen. So the role of the jury. The jury is considered a fact finder. They're supposed to decide what happened. They don't decide on what the law is. They don't decide on what the standards are by which we evaluate what happened. But they can be asked whether what happened rises to a certain standard. So does this constitute recklessness, with an explanation of what recklessness means. This is actually, it turns out, a big change from how juries operated way back when, at the beginning of the Republic, when juries were actually much more like groups of local notables who kind of set the tone and the rules for behavior. And so juries were actually much more involved in the production of legal standards in that common law way that we attribute to judges than we usually think of them now. Now we really think of them as fact finders, and that's why we say things like juries should weigh the evidence, juries should make credibility decisions. So they're the people who, when there's a contested story about, who was turning left and who was going against the light, they decide what really happened. The right to a jury trial is a constitutional right embodied in the Seventh Amendment, which says that it preserves the jury right for all cases at law. So, at law, remember when we were talking about pleadings, and we talked about pleading in the olden days before the federal rules were written. And we talked about how there were basically two litigation systems at that point from, like time immemorial, I don't know, the 13th century, until 1938 in England and in the United States. Those systems were common law, otherwise known as law, and equity. And the way those two were divided, as you may remember, is incredibly difficult to outline or remember or understand because it followed a kind of a historical development pattern rather than a kind of logical or categorizing pattern. For our purposes, I would say the main thing you want to remember is that ordinary damages suits, where you're asking for money, those were normally cases at law. And so a jury trial would have been available for them when the Seventh Amendment was written and is considered preserved under the Seventh Amendment. Injunctions, requests for injunctions, so specific performance, some sort of conduct or action, those were generally cases in equity. And so they did not have a jury trial available in the 18th century, and they continue not to. So sometimes in our cases, you'll see situations where there is a jury, and sometimes you'll see situations where there's not a jury. And one of the reasons is going to depend on what kind of remedy the person is looking for. Okay, so you have a right to a jury, let's say in a damages trial. How do you actually make sure you get a jury? Because it's not automatic. You have to demand it. And demanding it is enough. You have to assert your right to a jury. Either party can assert that right. And the time limit on asserting that right is within, at the latest, 14 days after the final pleading is filed. But often you'll see the demand included in a complaint or an answer. So it's often right on the face. And that's all you need to do to assert your jury right and get a jury in a case that would have had a jury in 1789. So who's potentially on the jury? That's called the jury pool, who we're choosing from. The court has held, and statutes now state, that the jury pool must include a representative cross-section of the people who live in a certain area. So that overcomes a lot of exclusionary traditions where people were excluded on the basis of race and gender, of course, but also on the basis of things like employment, parental status, marital status, and so on. So all of those kinds of categorical exclusions from jury pools are no longer allowed, and that's sufficiently well settled that it's not really subject to a lot of dispute or litigation at this point. The question of who actually ends up on the jury can be a little more fraught. So once you have a jury pool, a bunch of people called to be available to be on the jury, a subset of those people is selected to meet with the judge and lawyers in a particular case and effectively be interviewed. The interview is called voir dire, which is old Latin/French for to speak the truth. Because jurors are supposed to. And the judge or the lawyers, depending on how the courtroom is run, will ask questions of the prospective jurors looking for conflicts, bias, other reasons why a juror might not be able to make a fair decision in this case. And of course, I say fair, and it should be, the question should be fairness, but of course, every attorney is looking out for their client. So your version of what you think is fair may be somewhat oriented towards your client's best interest. Lawyers can strike, so kick off prospective jurors off the jury, and they can do that in two ways. So there's two ways of striking a juror from a potential jury. One is called a for cause strike. So if there's a reason to think that the juror won't be able to be neutral or fair, so they have some sort of relationship to the case, they have an economic interest in one of the parties, so a shareholder in a corporation that's being sued or suing, or of course they have a bias or bias for or a bias against towards some group represented in the litigation. Often that'll be either a racial group or a religious group, but also in employment categories. So if you have a prejudice against lawyers or police officers or accountants or whatever, then a lawyer or a judge may decide that that person is not likely to be able to fairly and neutrally adjudicate in a case involving a member of that group. There are also peremptory strikes, which means that a lawyer can strike a juror for no reason at all, so for no reason that they have to explain. You have 3 peremptory strikes of prospective jurors, and this historically has opened up the possibility for biased striking of jurors. So most notably, you have situations where there's a predominantly white jury with maybe 1 or 2 black jurors, prospective jurors, and a black litigant. And historically, all white juries are just much more likely to rule against a black litigant. And so lawyers, or especially prosecutors, have, again, historically used the peremptory strikes to mold the racial composition of the jury. So that has led to a series of constitutional cases limiting that effect. So Batson, the first of these in 1986, which is really not that long ago, held that lawyers can't strike jurors with peremptory strikes in criminal cases because of race. A few years later, Edmondson held that lawyers can't strike on account of race in civil cases as well, so that applies to the cases we study here. And finally, in 1994, JEB v. Alabama held that you can't strike peremptory strikes on account of gender in either kind of cases. So as you can imagine, this is a really difficult thing to litigate, but it continues to be litigated, and it clearly continues to be an issue, judging from that litigation. Finally, what if there is no jury demand? What do you do? Basically, the judge acts as the fact finder as well as the expositor of the law. That's called a bench trial, and that's actually very, very frequent. Whether you want a jury trial or a bench trial is really a matter of strategy and risk mitigation. And so it's going to be really particular to each case, where it is, what kind of jury pool you're drawing from, what kind of case it is, the claims, and so on. But that's a decision for the lawyers to make, although, of course, since either party can ask for a jury trial, there has to be both parties agreeing to have a bench trial. While we're talking about the judge, let's talk a little bit about how the judge shapes and manages the lawsuit. We've seen a lot of judicial management already in all the discretionary decisions that we've been talking about. But the judge is also, in a sense, the potter, the ceramicist who makes the shape of the lawsuit happen. And the judge does that in a few different ways, a lot of which are outlined in Rule 16. So Rule 16 requires a scheduling order at the start of the lawsuit, in which the judge, in conference with the litigants or their attorneys, sets the schedule for the litigation. So they limit time to join parties, amendments, set the time for discovery, set the time in which summary judgment motions must be filed, set dates for future conferences, basically organize how everything is going to go, what the schedule will look like. And this is the time at which a judge can modify the defaults. So the timing of disclosures, the extent of discovery, this is the first opportunity to issue protective orders for discovery and stuff like that. Rule 16C requires a pretrial conference to eliminate frivolous claims or claims that have been not pursued, to amend pleadings if necessary, to obtain admissions, to make evidentiary rulings, to figure out the timing and the propriety of Rule 56 motion for summary judgment, generally to control discovery, to refer any matters the judge thinks necessary to the magistrate judge for a preliminary adjudication, adopt any kinds of special procedures that they want to, for instance, to bifurcate the case if there's multiple issues that should go to separate trials or separate juries. Rule 16F provides for sanctions for noncompliance. So, for instance, the judge can prohibit a party from supporting or opposing a particular claim. We've seen examples of that already. They can strike pleadings, they can dismiss the action altogether, make a default judgment, treat violations as contempt of court, or fine people for noncompliance. So this is kind of where the teeth of Rule 16 is located. And finally, the 16E is the final pretrial conference and order where the parties meet with the judge and formulate a trial plan. And our next case deals with the force of that trial plan.